Court for the County of Sheboygan. We are providing public access both in this courtroom and online. And good afternoon, Mr. Clayton.
Good afternoon, Your Honor.
I did sign the stips on Taylor and McCumbee.
I appreciate it.
We brought Mr. Frisky out in the courtroom. People be Frisky 24-6860FH. We had adjourned this sentencing a couple weeks ago at the defendant's request, and then given some scheduling issues with his attorney, I'm told that Mr. Frisky has no objection to his attorney appearing by video today. Is that correct, Mr. Frisky?
Yes, sir.
Okay. Mr. Clayton, have you had a chance to review the pre-sentence report with Mr. Frisky?
I have, Your Honor.
Any additions, corrections?
No, sir. I was going to say, I'm also of the opinion the guidelines are scored properly.
Okay, thank you. Ms. Goodrich, guidelines were scored at 0 to 6. Any scoring challenges or additions, corrections?
No, Your Honor.
The only correction, I guess, would be now that we've adjourned it a couple of weeks, Mr. Frisky would, of course, be entitled to that additional credit. So by my count, that'd be an additional 14 days, bringing him to 15 days credit. Mr. Clayton, anything you want to say on behalf of Mr. Frisky?
Your Honor, this case obviously had a little bit longer path to get to where we are. We did try a couple different specialty court options that just weren't available to Mr. Frisky. And I don't need to go any further than that. He made the attempt. I think that you're looking at a case where you have a guy, he's got 2 drunk drivings about 20 years ago, roughly 20 years ago. It doesn't seem like it's a habitual kind of situation for him, but I have talked to Mr. Frisky at length, and it's a stated intention that he's going to gain and maintain sobriety for life. It's a lifelong commitment for him. I think he's better. I think society is safe if he's not drinking. Certainly not drinking and driving, but if he's not drinking, the court shouldn't have any concerns about that. He did apologize to me about last time we were in front of the court. I told him, I said, that's not necessary, but it happens. People get upset. You know, these are big situations, and I'd ask the court to follow the recommendation. The only addition I'd ask the court to do is Mr. Frisky, at least the last I talked to him, was still gainfully employed. I'd ask the court to consider allowing him to participate in the work release program so he can get back to work. But short of that, I think the recommendation of the state minimum mandatory required under the statute is 30 days. I think with the 0 to 6 guideline range and his age prior record, I think that recommendation is appropriate. I'd ask the court to follow the same.
All right, thank you. Mr. Frisky, it's not required you would say anything today, but it is allowed. Is there anything you want to tell me, sir?
I'd just like to apologize. I did to the attorney that it wasn't in my intention to not take whatever was coming to me, but I just didn't have enough time to get my affairs in order at my house.
Okay. All right, Ms. Goodrich, any recommendations from the people?
Yes, Your Honor, thank you. We are here because on April 3rd, 2025, the defendant had crashed into trees. He had received minor injuries and had a 0.198 blood alcohol level. He's 65 years old. This is his first felony. He has 4 prior misdemeanors. His 2 prior drunk drivings were 2002 and 2006. He is employed with a high school diploma. The guidelines are 0 to 6. We do have a sentencing agreement not to exceed those guidelines. I agree with the PSI recommendation for 30 days with credit for the 15 days served. However, it is concerning that he stated he usually drinks a couple and then hits the road. That was an unusual statement for somebody with 2 prior drunk drivings, and he still seems to be in denial about how serious the drinking and driving can be and how to prevent it. Thank you.
All right, thank you. Well, Mr. Frisky, if you'd please stand for the court's pronouncement of sentence. You know, your attorney and the prosecutor have both accurately laid out your history with criminal history and alcohol. And you're here for operating while intoxicated third offense sentencing. It carries a 5-year maximum. The advisory guidelines are 0 to 6. Because the 2 priors were so long ago, I think the recommendation, there's a mandatory minimum 1 month. Lots of folks, including your lawyer, will tell you it's not very often that an OWI third case gets only the mandatory minimum, because there's usually such a pattern of behavior going on that there's more incarceration than the 1 month. I think in this case, given your lack of prior felonies, the age of the priors, that's why I think the recommendation is just for the mandatory minimum. I think under these circumstances, that does appear to my mind to be appropriate. So I'm going to follow those recommendations. It is within the advisory guidelines. It is within the terms of the plea agreement. So I'm going to place you on probation, Mr. Frisky, for 12 months, subject to the terms and conditions listed on the pre-sentence report at pages 2 and 3. Those include, of course, support group meetings, substance abuse assessment and treatment, community service, employment, crime victims assessment of $130, monthly supervision fee to the Department of Corrections, court costs of $350, a fine of $500, $250 OUIL reimbursement, comply with DNA testing and pay a $60 fee, $68 in state cost. And I'll order that you serve 1 month in the Sheboygan County Jail and give you credit for 15 days previously served. I think that's too short of a sentence to really facilitate the work release program. So you wouldn't be eligible for that, but you'll be out within a couple weeks or less, depending on good time. Also on the judgment of sentence will indicate that any weapons that were seized will be forfeited to the agency that seized them, consistent with the plea agreement. Mr. Frisky, you are eligible to petition for discharge from probation early at the halfway point or beyond if you've successfully completed all of its terms. So we're going to hand you a piece of paper explaining that process. Also, if you wanted to appeal, you could do so by filing an application. If you wanted a lawyer appointed, you'd have to ask within 6 months. So we're going to hand you a piece of paper explaining that appeal process. We're going to ask you right now to initial 1 copy of the appeal paperwork so we have a record that we gave it to you. The other one is for you to fill out if you want to take an appeal. Do you have any questions for me, Mr. Frisky? Within 24 hours of your release, I want you contacting probation department to get going with your supervision. Anything further from the defense, Mr. Kline?
No, sir. We thank the court.
Anything further from the people?
No, Reverend, thank you.
Okay, we're all set. You have a good day, Mr. Kline.
You as well. Thanks, sir.
All right, and then we have a probation violation arraignment and people be Tor Brager Larson, file 22-6505FH. Counsel, you want to state your appearances, please?
Melissa Goodrich, Sheboygan County Prosecutor.
Liz Elliott on behalf of Tor Larson, who sits to my right.
All right, so do you prefer Mr. Larson, Mr. Brager Larson? What do you
The
prefer?
last name is Brager Larson.
Brager Larson.
There's no middle name.
Okay. All right. Well, Mr. Brager Larson, it's alleged that you are in violation of your probation in several respects. 7 counts. It's alleged in count 1 that you have failed to address your financial obligations ordered by the court to be paid to the Sheboygan County Clerk's Office. Count 2 alleges that you failed to attend AA or NA meetings as directed by your supervising agent. Count 3 alleges that you failed to engage in substance abuse treatment programming. Count 4 alleges that you failed to undergo a substance abuse assessment. Count 5 alleges that you failed to address court-ordered community service. Count 6 alleges that you have failed to provide ongoing proof of employment. And count 7 alleges that you have failed to address outstanding legal matters in Indiana and Iowa.
Yes.
You have the right to have a hearing on those allegations where they would need to be proven by a preponderance of the evidence. The rules of evidence don't apply at that hearing except as to privilege, but you are allowed to present evidence on your own behalf at that hearing and to question any witnesses that do testify against you. You have the right to the assistance of a lawyer. And if you can't afford one, an attorney at public expense. And Ms. Elliott is here for purposes of arraignment. If you are, and you're on probation to me for operating while intoxicated, 3rd offense, that carries a 5-year maximum. And if you are found to be in violation of these allegations, if there's 4 or more technical violations, the court can revoke your probation and sentence you to that underlying case with the maximum 5 years. So, Mr. Brager Larson, do you understand the rights that you have and the maximum penalty involved here?
Yes, sir, I do.
Ms. Elliott, do you know how he wishes to proceed?
I'm not guilty, for Your Honor.
And does he qualify and does he request counsel?
He does, and that would be Mr. Gilbert going forward.
So we're going to have to schedule this for a probation violation hearing and time slot appropriate for Mr. Gilbert. This was noticed up as a show cause. I am a bit troubled by what is alleged to be Mr. Brager Larson's complete failure to comply with the probationary terms I gave him. When at sentencing, I expressed some grave concern about his history, and I had even considered not following a plea agreement for a sentence within the guidelines and thought maybe he was even a prison case. I give him a chance, and he appears to have done nothing with that chance over the last 2 years. So I would like to hear from both parties about whether it's appropriate to continue Mr. Brager Larson on release in the community pending the hearing. Ms. Goodrich.
Your Honor, the people's concern is the failure to comply with count 2, 3, and 4 regarding addressing the substance abuse, which sounds like it hasn't even begun because he hasn't completed the assessment on an OWI third case that is a risk to public safety.
Ms. Elliott.
Mr. Brager Larson reports to me that he did have a substance abuse assessment. He owes some money, so that hasn't been released to the agent. He also reports to me that he's been attending some AA on Zoom. And he also met with his agent in Oakland County in person last week. And he reports to me that none of these violations were brought up in that meeting. So he was pretty surprised to see this. So he's denying these allegations, Your Honor.
Well, these alleged violations seem to encompass pretty much everything I wanted you to do on probation. It sounds like the only thing that you're not doing is getting arrested. And I specifically talked about these out-of-state warrants and charges. And the sentencing, he's been on probation for a couple of years now.
Yes, sir.
This is just not at all what I envisioned. I'm going to order Mr. Brager Larson to be held without release pending the hearing. He'll be in the care and custody of Sheboygan County Sheriff immediately. We'll schedule the hearing within 14 days as allowed in the court rule it'll be a little bit outside that. It'll be September 30th at 2:20 in the afternoon.
What was that time, Your Honor?
2:20.
Thank you.
We'll see you then, Mr. Larson.